We're live. All right, good morning. It is April 18th, our Senate Judiciary. We are taking up
At 44.
That's all right. Page
44. Not as supposed to.
Yeah. Made some changes and we have Ledge Counsel here to walk us through things.
Do you want me to share my screen? Or
Yes, please.
Will, do you mind just sending a link?
Yeah.
Yeah.
Should be coming to you.
Great, thank you. If you could give me share.
Should be good.
Okay. So for the record, Edwin Grosky from the Office of Legislative Counsel, with a strike all amendment to H44, that really only makes three changes that I've highlighted for your convenience in draft 1.1. So the first change is reflected on the bottom of page 1 onto page 2, and this is the excuse me, language that was proposed by the DMV to avoid the conflict with the federal masking law, basically that you can't mask or defer imposition of judgment or other forms of sort of alternative justice, for lack of a better term, for concealing it from the CDL database, basically. And this addresses that issue. So what it does is that it strikes, so you'll see, as it currently reads, that all juvenile proceedings filed pursuant to the juvenile statutes, pursuant, well, so basically this is a jurisdictional thing for the family court, except for proceeding charging the holder of the commercial's driver's license with an offense or violation listed in 23 VSA 4116, which is sort of a nod to the federal masking statutes within our state statutes that would result in the license holder from being disqualified from driving a motor vehicle if convicted. That's now being changed, except for proceeding charging the holder of a commercial driver's license or commercial learner's permit as defined in statute, for operating a commercial motor vehicle with any offense or violation of any traffic control law other than parking, vehicle weight, or vehicle defect. So basically, it accepts those CDL violations from the sort of privacy protections of family court, but also carves out parking, vehicle weight, and vehicle defect violations from those. So those would then be rolled into what could be confidential, essentially. So it's really the major violations related to CDLs that can't be masked from those databases. These language addressed it. Any concerns on that one? Okay. Then on to page 5 is the first change regarding what we were discussing in subsection J last time, about really setting the expectation that someone submit to the collection of an evidentiary blood sample when there's a warrant that's issued. And so this changes, you'll see it strikes shall not refuse to, so it moves away from sort of that consent language that was discussed, and now just says must submit to it. So it sets the expectation of what the behavior is in that situation. And then the other side of the coin is reflected on page 9, which gets at the new criminal refusal penalty. So you'll see before it was obstructs the collection of an evidentiary sample, and now it's replaced with knowingly hinders. And the explanation behind that language choice is that there is case law defining hinder now in the context of a different statute. But the Supreme Court has defined hinder as to slow down or make more difficult someone's progress towards accomplishing an objective, to delay or impede or interfere with that person's progress. So in this case, it would be the law enforcement officer's execution of the search warrant to obtain that blood sample. So what this does is create sort of an act that's required to actually hinder on the part of the defendant, hinder the law enforcement's progress to obtain that, the law enforcement officer's progress to obtain that blood sample. And then adding the mental state of knowingly, which means sort of having the conscious objective, or at least practically certain that your conduct will result in hindering the collection of that blood sample. If you just left it as hinder, it would arguably be a strict liability crime. So there wouldn't have to be any intent on the person's part. So there's a potential situation where if they're incapacitated due to intoxication and they're unable to they don't know what they're doing and maybe they're hindering, there's a question of what their mental state is there. And so based on the conversations that the committee had earlier, seemed that there had to be some sort of intent level to actually hinder the collection in addition to the act itself. So what this knowingly phrase does is accomplish that mental element that would be necessary as opposed to someone that may not be consciously resisting. Does that make sense?
Wouldn't that be an argument, like if somebody giving a test and they're over the legal limit, could they make the argument that they didn't knowingly, like if they didn't hinder that collection, wouldn't they be able to make the argument that they didn't know?
Well, yeah, I mean, and that's a fact-dependent inquiry. So, there'd have to be testimony, there'd have to be evidence of the level of intoxication. So it could create a litigation point, but that would be fleshed out by the courts. And this is something that they deal with regularly.
I thought ignorance of the law was no excuse.
All right. Well, yes, but this wouldn't necessarily be ignorance of the law. I think sort of what Senator Matos's argument is, well, could they argue that they weren't knowingly hindering what was going on if they had a certain level of intoxication, which, yeah, people argue their level of intoxication all the time about the violation of the underlying DUI itself, but not so much that what I'm hearing is that it's not so much an ignorance of the law, but just maybe a litigation factual dispute that may result as from this language.
Senator Matos pointed, and what the defense would have to do is bring up a diminished capacity defense. And there's a certain threshold or line that you have to get to prove diminished capacity, and diminished capacity doesn't apply to anything below knowingly. So you can't recklessly disregard something and then argue diminished capacity. That the diminished capacity defense only applies to knowingly and above. I don't know if that helps.
There wouldn't exactly be a logical line between those two arguments, you may not. Can't be reckless and knowingly at the same time. So those are the three changes to H44 as proposed in this amendment. Any other questions about it?
So in Senator Bruce's example, ignorance is no excuse of the law. Would the state have to prove or reason of ignorance now?
No, that would not. It's not.
Automatically.
That's not a burden the state would have to prove.
Stay away from that for a while.
Yeah.
Great. All right, well, we'll hold on to this for a little bit. I'm going on it next week sometime.
Those were the only two changes, right?
There's just those three changes, the, one proposed by DMV. About the
Oh,
maximum
and then-
provisions,
yeah,
and then the two involving the.
We've had so many of these bills from the House with very little changes, and I'm just wondering, usually wouldn't those get into a miscellaneous bill or?
Yeah, say could have, but I guess, I mean, we started with the miscellaneous bill, so they have it now. And
Yeah.
that would just,
We've had 4 or 5 where,
It's just miscellaneous.
yeah,
yeah,
just technical changes.
well, I guess it just give us more things to hold on to is, just like,
That makes us look super productive.
yeah, exactly. That's- I guess we can move right along to the next. It's just S-148.
Very with me.
Yeah.
It's situated there.
So if I state things into the budget that were taken out as error,
You want
that
to
shouldn't be
do,
held against me or spending.
you're the
Right.
producer.
But
I-
you funding 1.6.
Yeah.
That's what I mean, it's supports.
Yeah, I mean, I might
Right,
defer to you now, sort of the underlying.
Honestly, they did this.
I'll make through.
Okay.
Yeah.
Get around the course, guys.
That's a counting against them.
It's kind of against them, not against me. So I'm saying, the new one, budget. Because. This is just a help. That's all right. We just concur with it.
Yeah.
That's great.
Yep.
Good comment. Okay. So before the committee now is, S-148 as introduced, entitled an act relating to expanding Good Samaritan protections concerning immigration. So what this does is really, it does a few things. So one, this bill proposes to prohibit law enforcement agencies, officers, and persons acting on their behalf to expend any resources to assist federal immigration authorities with civil or criminal investigations or proceedings. This bill also proposes that these non-cooperation requirements extend to situations covered by 12 VSA 7306 and 18 VSA 4254. So those are like kind of the Good Samaritan protections, if you will, specifically. I saw.
Yeah, I didn't think we did incorporate the aspect of not expending any resources into this bill. I thought that that was Senator White's bill. Okay. Anyways, go ahead.
So, getting into the substance of the bill, so this would create a new statute entitled 20, which is the public safety statute specifically within the subchapter regarding the Vermont Criminal Justice Council. So it adds new section 2372 entitled non-cooperation with federal immigration authorities. It defines federal immigration authorities as federal agencies, departments, or employees or contractors of those agencies and departments tasked with the enforcement of federal law, federal immigration law and border entry, including the Department of Homeland Security, Immigrations and Customs Enforcement, and Customs and Border Control. And for context, this definition is drawn from the fair and impartial policing policy that's currently in practice right now, as implemented by the Criminal Justice Council. The real operative provision of this is subsection B, which mandates that no law enforcement agency, officer, or any other person acting on behalf of a law enforcement agency may knowingly provide any information or expend or use time, money, facilities, property, equipment, personnel, or other resources in furtherance of any civil or criminal federal immigration investigation or proceeding. Subsection C states that those requirements shall apply to law enforcement agencies, officers, and other people who are involved in any situation covered by 12 VSA 7306, which is non-cooperation with interstate investigations of legally protected healthcare activity, and 18 VSA 4254, which is reporting a drug overdose and any immunity from liability as a result of that. So any reporting due to drug overdoses or any interstate investigations regarding legally protected healthcare, these would specifically apply to those situations as well. However, there is an exception embodied in subsection D, which the section shall not apply to any law enforcement agency, officer, or other person acting on their behalf in the course of normal business in responding to a judicial warrant on the good faith belief that the warrant is valid in the state, or an investigation of a criminal offense unrelated to the enforcement of federal immigration law. Section 2 is the effective date, and this would go into effect on Friday. So this looks like a relatively short and sweet bill. But it has,
Sweeping.
it is sweeping. It implicates many constitutional questions, some of which, to be quite honest with you, are unanswered by the various circuit courts throughout the country and the Supreme Court. Specifically, I want to highlight for the committee this specific language of may not knowingly provide any information. So there are two federal statutes that actually require information sharing. Those are 8 U.S.C. 1373 and 1644.
Repeat those again, please. I'm sorry.
8 U.S.C. 1373 and 1644. Essentially, those two statutes require that state and local governments cannot prohibit their employees from sharing information about the citizenship or immigration status of individuals or of, as they phrase it in the law, of an alien. However, there is also the 10th Amendment of the United States Constitution, which reserves powers to the state. And the Second Circuit has not specifically addressed the conflict between these two statutes and the 10th Amendment. Most of the litigation that's occurred has occurred in the last few years, really about 2017 and on, that have, as I would phrase it, addressed adjacent issues. So the ability of the federal government to withhold grants for non-compliance with information sharing requirements, but not really that core issue of how these statutes conflict with the 10th Amendment. Now, the Second Circuit has facially rejected a challenge that said that basically these don't conflict, but you really have to get into the heart of the decision to kind of understand where that conflict is. And what they really talk about is the need of state and local governments to preserve confidential information, much of which may be acquired through these interactions and immigration enforcement proceedings. And so while they said that kind of on its face, there isn't a conflict, there may be one. They kind of are outlining a crystal ball, if you will, so in dicta, saying that this could be an issue if the federal government is trying to get at confidential information that is the state's right to maintain. And so that is a long way of saying this is a constitutionally gray area as far as what's permissible here.
Right.
What is not, what is relatively solid law is there is no requirement for state law enforcement agencies to kind of go above and beyond to help. There's no affirmative obligation on the part of law enforcement to assist. It's only if there is a required request, and that is only comes in the form of a judicial warrant, which is why you have that carve out here in this statute. Now, a lot of states have laws on the books that are similar to this, but they will qualify it except as required by law. That's kind of the end around, if you will. This is a little bit different because it doesn't have except as required by law. It makes two specific exceptions, which are if you have a judicial warrant issued to request this information, which means probable cause has been found by a judge of some sort of criminal activity, and now we're required to provide the information. Or there is an investigation of a criminal offense unrelated to the enforcement of federal immigration law. So basically, if there's, say, a federal drug trafficking charge and they're doing investigations, you can provide information in that context.
Senator,
Just wondering, what would be the penalty if this were to pass, make it into law, and then some law enforcement officer did spend time, facilities, etc.? What would the,
There's no real enforcement mechanism here. What would probably have to happen, though, is that if this were to go into a law, the fair and impartial policing policy that's in effect would have to reflect the changes in law. And so if a police officer knowingly violated the provisions of law through violating the policy, that would then be in effect. There are administrative actions that can be taken,
punishment?
professional licensing issues that could be adjudicated by the council, or internal affairs investigations with the law enforcement agency itself.
and could you highlight the differences between what our current fair and impartial policing policy is compared to what is being proposed in this?
I can do it to an extent.
Okay.
So the fair and impartial policing policy, as I understand it now, basically makes it so you don't have to, there is no expectation of affirmative help on the part of law enforcement officers. So some examples are, you cannot prolong roadside stops in order to get ICE or CBP to arrive to investigate for an immigration violation. You can't hold people in a station for the same purpose. There's no requirement to inquire from a state law enforcement officer's perspective or municipal to inquire about someone's immigration status. So those are the restrictions, some of the restrictions in the fair and impartial policing policy that are in place now, that kind of get to what is understood right now as permissible restrictions, if you will, on any affirmative help. This would, and in this bill, it's broader, it's not as specific. So it's anything where you would knowingly expend use, time, money, facilities, property, equipment, personnel, or other resources in addition to that information sharing. So it is more it's broader than what's specifically outlined right now in the fair and impartial policing policy. I think there's some context that's probably good to have for sort of what current practices are with ICE and CBP when it comes to these sort of requests, if you will. So right now, there's something that's known as a detainer request. This is something that is an official immigration form that is sent either by one of the immigration authorities to a law enforcement agency saying, we want you to hold this person for X amount of time, normally about 48 hours, so that we can get there and do our investigation. It appears to be a very official document. And from what I researched, many law enforcement agencies sometimes treat that as a warrant, maybe due to maybe ignorance, or because right now it looks like one. If you look at the form itself, and a lot of these official requests, and sometimes there's even civil warrants that these agencies issue, but they're not signed by a judge. They're all signed by immigration officers. And so that's why those type of requests would not be permissible to answer to under this law if it were to pass, because it's not a judicial warrant. So a judicial warrant is one that's signed by a judge.
It would be knowingly, would be the standard.
Exactly.
Yeah.
Yes. So just to kind of give you a lay of the land of what local law enforcement sometimes deals with when it receives these requests, and these are very official they are official forms, they're just not judicially issued. And so right now it is thought to be proper and appropriate and legal for states and municipalities to not answer those requests because they're not judicial commands.
I called it sweeping. I think that's accurate. I read this as if someone sent an email or a phone call would trigger this.
Like a state law enforcement officer.
Yeah.
It could, yeah.
Yeah.
Again, that knowingly, they'd have to effectively know what they're sending and who they're sending it to.
Yeah. Yeah, I mean, that's my, my trouble with it so far is it's basically, so we've been talking in the past week about whether the state should have an MOU with Customs and Border Protection. And that's one thing. Should you have a memorandum with them, right? Create an understanding under which you'll operate. If we didn't have that, we'd be neutral. But this goes way far in the other direction, for basically criminalizing almost any contact with immigration, as I read it, because any conversation could be read as furthering their investigation.
Mm-hmm.
So that's what gives me pause. Is it's sort of setting up a legal impediment to any contact. And maybe that's the intent, but just seems like it could. And there is the knowingly standard, but it's a pretty broad language.
It is.
Yeah.
And just to clarify, it would make that type of conduct illegal. I wouldn't say it's criminalized
Because there's no criminal penalties specified.
exactly.
Wasn't there, I'm struggling to remember, but it seemed to me like there was a default penalty in criminal statutes.
Yeah, but this is in Title 20. It's not
Okay.
the criminal statute, so it's in the Criminal Justice Council.
I see.
Uh,
So it's all professional
Mhm.
punishments or,
Right, and there is a process that where any person alleged to have committed this conduct, there is the administrative process. If they don't agree with one of the decisions of the council, they can appeal to a civil court, so it can lead to a court process. But this in and of itself wouldn't be a criminal penalty.
Sorry.
In section A up there, that sounds a lot like isn't it like the 287G agreements? It's 287G.
As far as the
31.
definition of immigration authorities.
Yeah, like
no, the ones in S44 that we said only the governor.
only the government. Is that what A is? Because that sounds a lot like.
I'm not sure. It could be. I can check that, but I drew this from the fair and impartial policing policy that's in effect right now by the council.
Because just over my, first reading and then hearing it again today, like when it says non-cooperation with federal immigration authorities, and then A, it sounds a lot like it's 287G, right?
Yeah, in S44.
Yeah.
Yeah. Yeah, I can double check that, but it wouldn't surprise me if it's similar, if not identical language. Consistency is always a good thing.
And we take a few steps back and just go back to the commandeering piece of the 10th Amendment and how that plays in here.
Sure. So, the 10th Amendment may further, at least specifically, may further limit 1373's reach. The 10th Amendment reserves power to the states, which prohibits the government from quote unquote compelling the states to enact or administer a federal regulatory program or commandeering state government employees to participate in the administration of a federally enacted regulatory scheme. So that's sort of the general concept of the tension between 10th Amendment anti-commandeering principles and potential issues that at least one of these statutes can raise.
And if you're able to, can you provide some of the, I guess, just the historical context of what the 10th Amendment is, why it exists?
So the going back to law school here, so the 10th Amendment is really the concept of whatever powers aren't specifically enumerated to Congress are reserved to the states. That was a main concern of the founders of retaining those states' rights so that the federal government wouldn't become this all-powerful entity that can kind of quell the sovereignty of the individual states. So that's sort of the underlying concept of the 10th Amendment's reservation of states' rights. Now, there have been cases about the anti-commandeering principle of the United States, the United States versus New York in the early 90s, which essentially got to the point of at what point can the federal government compel states or coerce them rather, or at what point does it become coercion or compulsion to kind of get in line with certain programs or statutes that they want the states to abide by. And a lot of that has surrounded grant authority. So that's a lever that the federal government can use with states to say, hey, we're not gonna, and this is a good example of this, I believe, is sort of when in the 80s, when the drinking age was raised to 21 across the country, it was contingent on highway funding. And so basically, in order to get the states to play ball nationwide, they said, well, we won't give you highway funding if you don't raise the drinking age to 21. Now, there is a certain point that, from my knowledge, the Supreme Court hasn't opined on yet about at what point does withholding grant funds and at what percentage does it become coercion. So is it 10%, withholding 10% of federal funds, 20%, 30%?
That's where we are now.
Right.
In the courts.
So there's not a clean answer there either, but the concept nonetheless exists that there is a point that you can't coerce the states through threatening to withhold grant funds to play ball with your federal statutes.
Because I'm thinking about the what's going on with education right now, and it's clearly meant to disrupt the education system, but force compliance. But they're going to do the same thing with individual states, like Maine. And it's not as simple as the highway stuff, because the Trump administration is, when they're angry at somebody, they just withhold everything. So Maine is being punished in 4 or 5 different ways. Not even to get something, it's just in retaliation for a remark that the governor made at a gathering. So
Yeah, and that is the kind of legal reality that a lot of these states are facing. And I don't have a crystal ball, but these are issues that will probably be litigated up through the Supreme Court on really where the balance lies. Again, going back to how 1373 and other statutes have been interpreted, in that Second Circuit case where they said no, like that is allowed. It was in the context of a specific grant program that they were saying you have to essentially certify these 3 requirements for the grant program in order to get it, and one of which is compliance with APSA 1373. And basically the Supreme Court, or the Second Circuit in that instance, says that it's okay for the federal government to do that, to require that compliance, one of which is information sharing. But like I said before, what they highlight is that there is an area of confidentiality that speaks to state sovereignty. They can make the decision that certain information is confidential and then cannot be shared. And but they didn't really make a decision on what that would be. But they made a tacit recognition, I'd say, that that's a sovereignty issue potentially that we may see at some point. But to answer your question on that, it's still this constitutional gray area.
In 2017, didn't Act 5 limit sharing with the federal government?
Remind me what Act 5 is.
So I'm looking at it now, and it was in response to similar concerns in the last Trump administration, and the governor signed that. And I'm looking here, hold on, let me find it. And it does talk about sovereignty and all of that, but it very clearly, sorry, I'm trying to find it.
What statute is it? Is it in?
It is, hold on, I'm gonna see.
Okay. I might have to just look into it separately just because I'm not familiar off the top of my head.
Okay. I'm just trying to find a very specific line where it says, a public agency shall not knowingly disclose personally identifying information to any federal agency or official for the purpose of registration of an individual based on his or her personal identifying information, and define personal identifying information as including race, immigration status, religion, religious practice,
Mhm.
national origin. So I feel like we've already waded into this.
Potentially, just knowing that there is a different context to that law, and so there are probably other federal laws implicated in that. So it's hard for me to give a well-informed opinion because I'd have to look into it more, but it's possible that the state has waded into the field, but
Okay, I can send this to you.
yeah, that would be good, just so I can, look into it some more.
And I guess the reason I bring it up is in 2017, we took action that was somewhat less than this, but we also saw less immediate danger. And so I feel like when we're looking at the landscape that we're looking at now, taking stronger action makes sense.
Well, and you'll see a lot of the cases that I mentioned were results of, they were 2017, 2018, and after that, so a result of some of the actions in the first Trump administration. But I think that you could fairly assess that most of these laws didn't go as far, and therefore those adjacent issues that were decided were maybe a result of that. The Supreme Court has a tendency to not decide issues they don't absolutely have to decide. And I think that's sort of a play here with the case law.
For sure. And I certainly, as I've said to you, privately understand that it's constitutional gray area, but I think we have an administration that is willing to run pretty fast and loose with the Constitution. And I think we have to protect people, and gray area isn't necessarily unconstitutional.
That is a policy decision.
Yes, I know. I'm making my policy case.
Committee, anything else on this?
Certainly not today, but I'm sure we'll have some discussion.
Well, and I should add as well that in 2017, the Attorney General's office issued some guidance related to this. I think that guidance probably needs to be updated with some of the current situations and cases that are coming up. But I do may be worthwhile to get some testimony from the Attorney General's office on these issues.
Yeah. That's fine. Well, you actually, at the AG, let's make a note of reaching out to the AG on this, please. Committee, anything further? And we also, if you're prepared to do so today, would we also be able to bounce to the MOU conversation?
Okay.
And can you just set the groundwork for that piece, please?
So you want me just to kind of speak generally, or do you want me
Yes.
to?
Yeah, generally to start, and then I think there might be questions. I have some questions, and yeah.
So do you want me just to go over sort of the general concept of what we can do with
Yeah,
MOU?
what we can do, what, if any, binding elements there are in this MOU? Is it a contract? Is it a grant? What is it exactly? Can we change anything?
Yeah, absolutely. So I can go through that. So the current memorandum of understanding is between U.S. Customs and Border Protection and the Department of Corrections in Vermont. Essentially, what the agreement does is the department accepts and agrees to provide for the secure custody, safekeeping, housing, subsistence, and care of federal detainees in accordance with all state and local laws, standards, regulations, policies, and court orders applicable to the operation of the facility and consistent with federal law. So essentially, layman's term, just an agreement to house people that are being investigated and detained by CBP in our state facilities. Within that, There are certain division of labor, so to speak, between the two parties. CBP and Border Patrol agents will adhere to their own policies when it comes to transportation, security, escort, and detention procedures. Those agencies shall have access to the facility, and federal detainees housed there during business hours. A 24-hour notice is required to access any records pertaining to the agreement itself, including financial records, for a period of 3 years. And then overall management and operation of the facility, housing detainees, can't be contracted out, so it has to stay with the department. There's a division of labor when it comes to medical services. Basically, DOC is responsible for all care that happens within the facility, all health care and their medical needs. And then anything that happens out, so if there's a hospital trip that's required, the federal government is responsible for the expenses regarding those external care procedures. The reimbursement rate, federal government reimburses the state of Vermont a fee of $180 per night per federal detainee. That's billed monthly. This is a 1-year agreement that started from the day in which the last party signs. I don't know the specific date that the last party signed, but it was sometime in August. Now the agreement may be modified, but it has to be upon mutual written consent of the parties. The agreement can be suspended, revoked, or terminated, but that requires a 120-day notice ahead of time, which, let's say it were to happen today, it would not, it would be August again. So right now, the natural termination of the agreement is in August. If there was a cancellation request, it would also occur in August.
Is there any precedent in other states for ending the agreement or sort of outside of that window?
Outside of 100, I'd have to look into that, but that would be subject to standard contract law analysis, and there'd be.
There is, I mean, there's.
I don't think California has these in practice now, but I don't know about the cancellation question.
I know the name of the concept is escaping me at the moment, but I know there's a
Rescission.
it's not that, but it's making law that retroactively changes a contract to the benefit of the government, which I know is prohibited. But so if this contract / MOU ends in the near future, just because it's hit its timeline, or if we were to create a law that prospectively sets some guidelines for who can be detained and for what when it comes to federal immigration, that's what I'm thinking of at the moment. I mean, my main concern is making sure that individuals who are detained or who are living in Vermont or have their hearing pending in Vermont remain in Vermont, but there is a second category of individuals who are being picked up in other federal districts, promptly transported here or to another federal district, which leads to the inability for their attorney in that original district to file a petition for habeas corpus. And so that in that second category, those detainees are then brought here or another federal district away from their attorney and their family. And so is there a path in which we could make it clear that if any federal detainees for immigration related actions, if they are detained in Vermont or they're a resident in Vermont or they have a hearing pending in Vermont, they can be detained here, but we will not be accepting detainees from other federal districts or arrested in other federal districts.
I think that's a possible path forward where you could essentially, prohibit the contract, so to speak, but then carve out certain exceptions for those detained here or having cases pending here. I think it gets a little bit more complicated when it comes to Vermont residents specifically. Because if they were detained, or have a case in another jurisdiction, you're almost telling the federal government, well, you need to move them here. And we'll detain them. But I guess it depends on sort of the scope of that term. But that could be a potential issue because really the states can't tell the federal government what to do.
Right, and I'm thinking more in lines of if it's somebody who is arrested in Vermont or has their hearing in Vermont. Yeah, that's,
Yeah, that is easier to do since they're already here. You know, typically they start the process right away after detention.
but if somebody is a Vermont resident, but they're picked up in Maine,
We can't.
that could,
Right. Yeah, it's more complicated.
yeah, Senator Rhodes.
So I certainly understand that we can't tell the federal government you have to do this, but I think as I think about this, it's less about telling them that they have to and more about making sure we carve out an allowance that those people can be here. And so, so we're not prohibiting so broadly that we have someone who under the current contract would be held here that's now being sent somewhere else. So it's more of an allowance in any of these instances that they're allowed.
Right. I mean, I suppose depending on how it's framed, if that's something that maybe in legislation, it's almost a direction to negotiate that level of like permission essentially within that contract. That if basically the federal government and the state agree that like, no, if you pick someone up that's in Vermont, please bring them back here. I mean, they agree to it, they agree to it. So I don't, my initial read is that wouldn't create the same issues. I'd still want to look into it.
Of course.
But that could potentially be a path forward.
Okay.
And so I'm not sure if this is similar to what you're saying or what you were saying, but to simplify it, what if we, in the MOU, we sought to revise it so that it said we would house federal detainees, but only if they were detained in Vermont. So that gets rid of the problem of, is there a Vermonter in Utah that gets detained? I just don't think we can do anything in that instance. Or we could say Vermont residents and people detained in Vermont. And then if the government wanted to take the Utah detainee and bring them to Vermont, they could.
Right.
But we would be saying, we wouldn't be compelling anything. We would say only in the case of detainees who are Vermont residents or were picked up in Vermont, will we provide this service?
Right.
And that gets rid of the worry that we're going to be a stop away station that gets used for people who get picked up in California and Utah and around the country and then flown to Vermont and then on to other locations.
So is your question really almost like a legislative direction?
Well, I guess it's more because as you stated, we can revise the MOU with agreement on the other side. So I'm just wondering, could we propose that because now it's just anybody that they bring to us, unless we have full capacity in the prison, we have to take them. But if we revise the MOU and we said, we will only detain for the federal government, Vermont residents or people who are picked up in Vermont. It seems like we eliminate a lot of what we're worried about and we protect the people that we are most concerned with.
Yeah, I think that's possible.
If I could interject, I think just regarding capacity, I think it's important to note that we are currently way over capacity at a minimum of 130% capacity in our jail, and there is an increase, to no one's surprise, of the federal immigration detainees that we're seeing. The thought that I have is that if the MOU is going to be modified, I think that's something that DOC would have to do itself. But I think that, and I'm happy to be corrected if I'm wrong, but I think that generally speaking, what we can do is essentially just establish a guideline saying that if there are going to be federal immigration detainees in Vermont facilities where we will be expending Vermont resources and Vermont employees in support of the federal government, then those detainees either have to have been detained in Vermont or have their hearing pending in Vermont. That's
another path that sort of, and I think that's sort of what I was getting at initially, Senator Bruce, when you're asking, like almost a legislative direction to the department to negotiate within these certain bounds.
Yeah.
When that is sort of what I was asking about, is that this pathway, which I think is getting at the same thing, but we can't tell the feds what to do, but we can tell DOC what to do. And so it's a direction to DOC to say, you need to renegotiate that within this landscape.
Mhm.
And just to follow it out one step further, I guess what I'm thinking is that in either case, the road ends with Phil Scott. So Commissioner Demel's not gonna make this change without the governor, so he's not gonna renegotiate the MOU without seeking guidance from the governor. And if we send a bill, it's gonna land on Phil Scott's desk. So it seems like in either case, the governor will decide this direction. I'm not saying we shouldn't pursue both, because, you know, why not? Sending him a bill and pressuring the administration to revise in a certain direction consistent with the bill. They don't seem mutually exclusive. We could do both. Yeah.
Yeah, no, I think I would agree with that, given the sort of urgency that I know I feel, I think kind of going down both pathways makes a lot of sense to me. And my understanding from, just reading the news articles is the concern the governor expressed is that is sort of met by saying in these instances, we can keep people in Vermont, but we're not going to be a way station in the sort of human trafficking of people.
And honestly, that was one of the problems I had with the governor's response. It was why I'm not going to terminate the MOU, not why I'm not going to find a viable revision of the MOU, because that was what prompted the whole thing was discussions, especially in the House. We're not going anywhere with the governor's legal team. So yeah, I would be very comfortable with that direction if this bill were revised to go along those lines. I think that would make a lot of sense.
And could we get language that creates that type of guideline for the
Yes.
district?
Yeah, I can do that. And I just want to flag for the committee too, that, I think the setting those guidelines and those boundaries is appropriate for the legislature, but it comes up against the line of, you can't really have legislative approval of an executive branch contract. So that's sort of the dividing line.
Yeah.
Just for the committee's awareness. And then we were talking about capacity for a moment. There is language in the current MOU that states Vermont retains the ability to reasonably refuse admittance due to capacity at the time of intake at a facility in superintendent's discretion. Now, this is really a recognition of Vermont law in 28 VSA section 102, which is the commissioner's responsibility to essentially run the department as he sees fit, in addition to the facilities. And then there's also the superintendent's legislative authority to essentially admit and refuse admittance of people under his or her care. So that's legislative authorization in our laws that seems to be recognized, at least in a form in the current MOU.
When you were reading it, it said consistent with state law.
That provision, no.
But somewhere in there.
It was as far as the Vermont agrees to accept and provide for the secure custody, safekeeping, housing, subsistence, and care in accordance with federal state law. So you could make the argument.
Well, so what I'm wondering is if, to Senator Buchowski's point, so we can't tell the executive branch to do, but we can say that resources will not be expended by Department of Corrections to house federal detainees unless they meet these conditions. And that way, it seems to me the MOU has to be consistent with the law rather than vice versa.
Yeah. And that's how it would be anyway, is that if you pass a law, either considering the MOU or not, any contract that's passed subsequently or signed subsequently.
Yeah.
Exactly.
Yeah, you can't write illegal contracts. The language that you and I have been discussing, does that get at what we're talking about now?
It's a little different.
Okay,
It's not as targeted at the, those bounds.
And obviously this is an S bill, so didn't make crossover. But given the circumstances, if we can get something together, I think there's a good chance we can get the House to agree to fast track.
well, we could find a vehicle for it too.
I don't know if do we have anything that is remotely related to this that hasn't passed? That this could be germane to?
S-148.
Well, you still have the
So
crossover.
you still have
Yeah, that's the process
something
problem there.
that's over.
This is a money expenditure though, isn't it? Couldn't it go in the budget? No, I was also wondering if it could go in the budget.
Well, and honestly, we've been trying to keep the budget clear of these kinds of things. Because we don't wanna draw a veto on the whole budget, just the next thing.
So miscellaneous judiciary, you would mention? something like that.
Yeah.
And that's in the House now, and they're gonna have to send it back since they made changes.
There's S-44.
S-44, oh yeah. They are,
That's about it. Reasons.
Yeah, okay.
so one of those two.
Although when I'm feeling like they've had so much trouble, I feel like once we get that jump on it, and we send it back to them, I don't know what's there.
Yes.
Although they're moving it now, right?
Yes.
I can talk to my colleague or say, oh, sort of.
I just can't understand what trouble they had with moving a piece of stuff.
Hold on. Thanks for bringing.
I don't, I think. I mean, I don't understand either, but I think that the urgency of this, we should do the work that we think is good and let the House deal with the House's.
Yeah.
Stuff.
Yeah.
If that's the vehicle, then
Miscellaneous might make more sense.
So the actual request to draft, so just to clarify, kind of setting boundaries to negotiate the MOU. Is that-
Well, it's more that I would like it to just be a guideline for the future. So I guess it could be regarding negotiating an MOU, but my preference would be that we establish a guideline saying that any federal civil immigration detainees, or rather, any federal detainees who are facing civil immigration actions can be detained in Vermont facilities so long as they have been either detained in Vermont or have their hearing pending in Vermont.
Or remote, that's it.
Well, the Vermont resident piece, I think, gets at the issue with if it's a Vermont resident who's not in the district or not in Vermont. You had highlighted an issue earlier, right?
Yeah, I think it depends on sort of how far you go with it. If it's something that you essentially want to say that a goal would be to agree to have Vermont residents held here, that's not really a mandate. It's really just a negotiation point that like you're expressing a desire to see, but you're not saying it absolutely has to be achieved. I think that might straddle the line.
Okay.
But we're still kind of in that almost telling the federal government what to do, but we're pulling back a little bit.
Not sure who had their hand up first, but several.
So- I'm at a loss as to how allowing a Vermont resident to be housed here is telling the federal government to do anything. We're not saying they have to be, we're saying they can be.
So, well, and it's a fine line because, I mean, ultimately it would take the federal government's agreement to do that. Because really how this would play out, like, let's say, in the Utah example, someone's apprehended there, they're going to be held at a Utah facility. There'll be arraigned probably, in the jurisdiction where they were apprehended. That's where their case is. Normally for them to get to Vermont, there'd have to be, a motion filed to, either a jurisdictional motion, a venue motion, maybe just a transfer motion, for various reasons, like maybe better family connections here, things like that. But it would go through that litigation process, and if it's granted, fine. And then the person will be moved. But that's sort of the process that, concerns the independence of the judiciary and the federal government.
Right, I understand that. I just don't want to put guardrails in that would prevent that person from moving back to
Right.
Vermont. And so that's what I don't understand about how there's any gray area. We're not saying they have to come back to Vermont. We're saying they can.
And I think you're right. I mean, the reason we have an MOU is because we don't have to take federal detainees. We're agreeing under certain conditions to take federal detainees. So we would just be saying in this piece, we will take this group, and this group. We will not take people outside of that group. And then that does, I don't think it's a formal conflict with executive power. I think Phil Scott will regard it as limiting his power and would probably threaten a veto for that reason. Because with the memorandum of understanding, he has complete ability to say what's going to happen, and we would be cutting that power. But to Senator Bielanski's point, I don't think it's a legal thing that we can't do. With the memorandum of understanding, we specify conditions under which we're willing to take prisoners, and we're just saying as a guideline, we're not going to, until further notice, accept people who are detained out of state or for out of state residents.
Right, so for now, let's just have, if it's, or a Vermont resident may be detained, right, in Vermont, along with the two other categories. So,
Yes, maybe you don't have this answer, Jim. Thank you for letting us chime in here. So it's my understanding that Vermont law enforcement officers don't enforce immigration laws. But having said that, I was wondering what's referred to as a green card. And we talk about a Vermont resident because you're in possession of a green card. Because I don't know this answer. Is there a time limit after 1 year, 5 years, or 10 years, you're automatically a Vermont resident? Or what happens with the green
So
card?
I can't speak to the green card, but just as on the concept of residency and domicile. So there are various definitions in Vermont statutes about who qualifies as a resident. So that's sort of a policy decision that would have to be, I think, considered here is who is defined as a resident. There are constitutional issues with sort of, acquiring benefits after you've lived here for a certain amount of time. But, I do think something here that the committee would have to decide is, well, who are we talking about? Who qualifies as a Vermont resident? Is it people that own a home here? Is it people that just reside? Because domicile is a different definition than residence. Domicile is intent to return. So for instance, like someone goes to college from Vermont, they go to college in Massachusetts, their domicile may still be in Vermont if they intend to return here, but they're just a resident of Massachusetts while they're in college. So these are sort of the larger questions that when you say Vermont resident, what do you really mean? And what I can do is kind of I can look through the statute to pull those various resident definitions for you to consider and help inform your decision.
I think that, if I remember correctly, I think the tax department defines it as having been domiciled in Vermont for a minimum of 183 days. I think that's their definition. I might be incorrect, but
Yeah, and I don't know off the top of my head, but I do know that in other contexts, there are different definitions of who is a resident. That could be the tax department one, and if it is, it's one that I would inventory for you.
That would be helpful for me to look at the different options to figure out what we mean. Certainly shouldn't be owning a home, given that that is a price point out of reach for many.
Are there any specific, like within the guidelines outside of those three different groups, anything that you would want to give some legislative direction on what those guidelines would be? As far as terms to negotiate within the contract outside of just permitting these three groups?
I mean, I'm hesitant to get too deep into establishing what guidelines can be created for executive branch negotiating contracts. I'm more so seeing this as the legislature establishing a guideline or a law specifically as to what categories of federal detainees our facilities are willing to accept in their beds.
Okay.
That's what I'm seeing it as.
Okay, so I can create that general guideline. And then I'll list Vermont resident, and then I can come back with, a selection of statutes that define it various ways for the community to cross-reference.
My only question, and we may need to hear from DOC on this, was if, my understanding is that the reimbursement rate doesn't actually equal what it actually costs to house people. And so I do wonder, and maybe this is more of an appropriations conversation, if it makes sense to set some guidelines around not at least breaking even.
Right. Yeah, my understanding is that it costs approximately $299 a night to house these individuals. And the contract right now is for $180 a night of reimbursement. So
Right. So we lose $110 a day.
and my understanding is that that 180 is exclusive of medical care with the facility. So it doesn't fully capture that as well.
Yeah, and so that would be my only other question, given how much we're hearing about costs and how we need to budgetarily be careful if there needs to be any discussion about, a contract breaking even at the very least, not expending money. But I don't feel strongly one way or the other. I just want to put it on the radar that is an additional consideration to think about.
So hearing that, I'll keep that out of the initial draft maybe, but just take a note of it to consider in the discussion.
Right. Any other comments or questions? Okay. Well, I think that's a wrap for today. And we'll hear from you next week.
Yeah, when I'm here to serve.
Great. We'll follow up on.
You do great. That's what pays.
Thank you.
My pleasure.